good morning. We're here this morning to consider Senate Bill 42 by Chairman Smith. I think what we're going to do is, depending on the length of the witness list, and it's got some length to it, is we'll go ahead and hear it for an hour this morning. The plan is to go ahead and hear it again tomorrow morning at 8:45. 8:30 is just not realistic. 8:45 until 10. You live and you learn. Trial and error. And then we'll come back tomorrow afternoon. We've got some short calendars, obviously, in the immediate post-Day 30 world. We'll come back tomorrow afternoon from 1 until 2:30. We'll see how far we get there. If we don't get through then we'll come back on Thursday morning. The method here for members of the committee is that we've got bills and Senate bills in subcommittee right now. As those bills percolate up through the subcommittee process, I think our time is well spent by focusing as a full committee and the committee of the whole on Senate Bill 42, obviously given the importance of the subject matter, with the intent of a substitute being presented for the full committee's consideration late this week, more likely than not early next week, and then move on from there. And by that time, members of the committee bills will have percolated up or down, as the case may be, from subcommittee to full committee, and we can go ahead and manage the workflow halfway effectively. That being said, before we begin, let me go ahead and introduce some folks that I recognize in the audience. Former Chief Justice Norman Fletcher, State Supreme Court of Georgia. Welcome, sir. It's a pleasure to have you here. Our Superior Court Judge of the Week, Judge Billy Ray of Gwinnett County. There he is, right in front of Justice Fletcher. And our State Court Judge of the Week is Judge Jeanette Little from Droop County. Would you, Judge, where are you? She's not here. All right, very well, thank you. With that, let me ask Chairman Smith to come forward. We're in a hearing-only posture from now, probably for the next few days, and so we'll get going. Other members will go ahead and trickle in, but we need to get going and get the process started on it. Chairman Smith, as always, welcome. What we'll ask you to do is to, of course, make whatever opening statement you'd like to make. Ultimately, we'll end up going around the horn a couple of times, once, probably twice, and questions for the author, and then you'll be released, and then we'll go ahead and hear from other witnesses and march on from there. So again, welcome.
Thank you, Mr. Chairman, and distinguished members of the Judiciary Committee. I appreciate the opportunity to present Senate Bill 42. And actually, at the outset, let me summarize in about 2 sentences 2 bills that are really companion bills that you'll end up having both before your consideration, and they have to go hand in hand in order for the package to work. Senate Bill 42 is a bill that will change or reorganize the structure of the Public Defender's Standards Council into more of an advisory body rather than a policy-making body. Senate Bill, and I will come back to the reasons for that bill. Senate Bill 100 is a bill that goes along with Senate Bill 42, and Senate Bill 100 has the purpose of making sure that the employees that receive a retirement underneath the current council structure, the references to their retirement are transferred over and under the new agency, so that as they continue working, they will continue to have their retirement in place without any lapse. And that's the only purpose for Senate Bill 100, but without that, the employees that would have been working there would no longer have that retirement. So it's an important, albeit small, piece of legislation. Senate Bill 42 is the underlying bill and the purpose for which I'm here today. And let me start by saying to you that Georgia made a commitment a number of years ago that we wanted to have, as a policy of this state, a strong, feasible, practical, and workable system of providing defense to the indigent as required by the Constitution. And the legislators, both then and now, have continued that commitment, and we, and I know you, and certainly I include myself in that group, want the system to succeed. We have a constitutional mandate to provide an adequate defense to indigent people who are charged with a crime. And that is an important constitutional duty, and it is important that that service be provided not only to protect those who are charged with crimes, but quite frankly, so that the rest of the system works as well. So I believe that we need to ensure this system works and that it works now and in the future. And we have reached a point in the growth and development of the system where we have a council that, in my view and the view of many others, has largely become dysfunctional. And it is now hindering rather than helping the efficacy and continuing success of the overall system. And so, despite some of the allegations that have been thrown around, my intent with Senate Bill 42 is not to dismantle Georgia's public defender system. It is not to end the provision that is required by the Constitution that we provide adequate defense. To the contrary, it is to try to find some way to make this system work. And right now, and I will certainly summarize my remarks and condense my remarks, but I can give you countless examples of how the council has refused to work with the legislature and even its own staff to ensure that this system works and is able to carry forward into the future. There is a continuing debate over what it means to provide adequate assistance of counsel in Georgia. What does that constitutional mandate mean? You will hear from people that say they have no choice. The Constitution requires this. In fact, they will. The opponents of Senate Bill 42 will wrap themselves in the flag of the Constitution and say there is no alternative. We must do this the way we're doing it. And while it is true that the Constitution requires this, it is also true that the level of defense that some are promoting is not in any way required by the Constitution. It is the view of a few people on a council that think that this level of defense is the appropriate level of defense. And while they defend that in constitutional terms, you cannot actually find in the Constitution or any of our court's decisions language which supports the kind of defense and expense that these advocates are suggesting we must provide in order to meet our constitutional requirement. So keep that in mind. We're not arguing that you don't provide an adequate defense. To the contrary, we're trying to make sure that we can do that. What we are arguing is that in order for the system to work, it requires balance, it requires management, it requires practicality, and it requires an understanding that when you provide this defense, there is ultimately, at the end of the day, a scarce number of dollars. And those dollars have to be allocated across all the state's needs, the needs that are constitutionally mandated and those that are not. And so we make a decision as policymakers on how we distribute that money, and we have to balance all of those state needs. And so to suggest, for example, that none of the other state needs are important or should be funded or balanced with the needs of funding a defense for the indigent, to suggest that is not important or even as important as this because there is a constitutional mandate is a flawed argument, because we're not arguing you don't provide it. We're arguing that you provide what the Constitution requires, and then to the extent you want to build out a system that is richer than that or provides more than the Constitution requires, to that extent you must balance that desire against the desire to provide the other needs that the state and the state citizens have. So that's the basis for the argument to this change. And of course, we've reviewed the cases by the Supreme Court, and the justices have had countless appeals on the issue of inadequate assistance of counsel. And the justices have reviewed those cases and rendered opinions about what constitutes a minimally adequate defense under the Constitution. And time again, our appellate courts have declined to overturn convictions on the basis of inadequate assistance of counsel based upon facts that are egregious on the part of defense counsel. Cases that I believe I would have said that is inadequate assistance of counsel, and yet our courts have said no, it is not. It meets the constitutionally minimal requirements that we have. Even the federal courts have taken this issue up. In fact, there was a Fifth Circuit death penalty case in 1999 where the defense counsel in a capital case was sleeping at the counsel table. And they appealed on that basis, and the courts did not find that to be. And it was a matter of fact. It was not a disputed fact that the counsel slept during significant portions of the capital case at counsel table, and the courts did not find that to violate the defendant's right to adequate assistance of counsel in that case. It's a case-by-case analysis, but my point in telling you that is that not that we advocate on behalf of a system where you have what is arguably inadequate assistance of counsel, but that those who argue that we must provide a very high level of defense, an O.J. Simpson-style defense for people, cannot justify that on the basis of either the Constitution, our statutes, or in the cases rendered by the very people that argue that we have to provide more of the state's money. So we have gone through this over several years. In the year 2000, the state of Georgia provided roughly $54 million, most of which came out of county funds for the provision of indigent defense for all defendants in the state. In 2008, that number had roughly doubled. We were at roughly $105 million in state and county funds and fees and fines that had been provided. So we had doubled or seen doubled the amount of money that was spent on indigent defense in just 8 years. I say that to also say to you that you will hear argued that we've been cutting, that there's less money every year, that we don't put a priority on funding indigent defense in Georgia. And I would say to you that if you look at the year-end budget numbers for each year, starting, you can go back to 2000, or you can start the year that this system started, when we first funded it and created a revenue stream to help fund it, you will see that every year we have provided significant money, and with one exception, on every year that money was increased rather than being cut. So there is a demonstrated priority placed on this issue by the legislature, by the House and the Senate. Now, this year, the members of the council, which we formed as a legislature, and we allow to continue to exist to help partner with us to provide this constitutionally required defense, have taken to the media to call us, you, thieves, murderers, kidnappers. They've alleged that you have hijacked the system and that you want to dismantle public defense in Georgia, and that you don't want to provide the adequate criminal defense, and that there is no alternative but to spend more money. And we have struggled with how to respond to that, with a council that will not only fail to work with us on requests that we have, but then will openly attack the very people that try to set policy to help provide indigent defense in Georgia. And it's frankly, it's been a struggle to have them attack us in the media and publicly, and then turn around and ask us to provide certain things and us to wrestle with what is the right policy. But it demonstrates a little bit the state of mind of those that are currently in control of this council, who are willing to make those statements rather than to continue to partner with us and make a public policy argument for what is best for the state. We have asked for a number of years for some predictive modeling in the budget area. Help us understand what this system should cost so that we can understand what needs to be funded to provide our constitutional mandate. And to date, as of this morning, after more than 5 years of asking, we still do not have a response to that question. We have asked them to provide us with what we refer to as a zero-based budget, which I know you all understand is a budget that simply goes through the code and says, what does the code require us to spend? What does the Constitution call for us to spend? What is required? And build us a budget that shows what is necessary to fund that. And then if you want to do more, make that case. But first tell us, as a matter of base, what the statutes and the Constitution require and how that's justified throughout the code. And we have asked and asked and asked, and they have simply and flatly refused to do that. And the only response we've gotten is the question, how much does a fund allow us to spend that raises money through fines and forfeitures? And I'll tell you that, and I've made this argument before, I think that is the completely wrong approach in figuring out how to spend money to provide indigent defense. The question is not how much money is available to spend. The question is how much money needs to be spent to provide the service. I mean, it's something akin to going to purchase a good or service, and if you ask how much should it cost, and they respond how much money is in your wallet. I mean, you're in that situation, you would stand somewhat aghast at that question. If that's the question we've been asked over and over again, we created a revenue stream in a special session with House Bill 1EX, and we created that stream to help provide revenues to support this system. But as you all well know, and the lawyers that run the council certainly should know, the Constitution does not allow us to dedicate any stream of funds for any particular purpose. when we create revenue streams, those revenue streams go into the general fund of the Treasury, and then we as a policy-making body and through the appropriations process sit down and see what the needs of the state are, and we appropriate on that basis. No one, and I know this all too well for other programs I've worked on, no one is guaranteed an earmark unless it is placed into the Constitution and the voters of Georgia vote on that. There is no such thing in Georgia. So the notion or the argument that's made to you that the council is entitled in some way to the full appropriation of any revenue stream is a completely flawed argument and is patently unconstitutional. We did create a revenue stream, and then we went back and we intended that to help cover these expenses, and we went back and asked how much should this system cost, and the answer consistently has been, why can't we get more money? Why can't we get the full amount of a revenue stream? Why can't we get additional money from you? How much money do you have? And frankly, if that's the question, then we will never satisfy those that want to spend money on indigent defense. In the previous system, when lawyers were asked to represent indigent clients, and I know different counties did it different ways, and we had some disparities, and that's at the heart the reason why the system was created. There were some inequities and disparities from county to county and circuit to circuit on how indigents were represented in criminal cases. And their representation in some counties was very good, but in some counties where there were fewer lawyers and lawyers that weren't as experienced in the criminal process, the representation was not so good. And so in order to cure that problem, we passed a statewide solution. But under the previous system, and I've been in this situation myself as a lawyer, and I suspect many of you have, the court would simply appoint you to represent an indigent person who is accused of a crime. And when they did that, you took that case back to your law firm or your private practice, and within the context of your other priorities, within the context of your other clients, both civil perhaps and criminal, you sought to represent that client ethically, zealously, to the best of your ability, but also you balanced the needs of that client against the needs of all the other clients that you had. I mean, that happens with every lawyer, public or private, even today. One of the factors that you considered was the amount of money that you had available to spend on that defense, because no lawyer could or would bankrupt his law firm or neglect all of his other clients for the sake of any one particular client. It's always been a balancing act, and it always will be a balancing act. But under the new system, we have essentially removed all financial considerations from those who represent the indigent. We've placed the checkbook in the hands of the state and asked lawyers to satisfy their ethical requirement to zealously advocate on behalf of a client without the normal financial considerations that one would have in any other context in their law firm. So it is not surprising that at least in the conflict area of the law, where we have conflicted out cases to private attorneys who bill the state by the hour, since they no longer have any financial constraints to consider relative to what they had under the previous system, you would expect that every year the cost of the defense, the quality and quantity of the experts hired, and what is placed into the cost of providing that overall defense will increase on a significant level year after year after year. And I think that's a structural issue. Anytime you ask a lawyer to represent a client zealously, and you remove all financial considerations from that attorney, you're going to have an expectation that the cost of that increase. And I think we have seen the cost of the conflict cases increase. We've seen cases both in the capital context and outside the capital context, where the expenses are very hard to justify. And you know, there may not be a better poster child case for this than the Brian Nichols case. I refrained from making public comments about that case during its pendency. But now that we are looking at that case in the rearview mirror, I think we are free to evaluate that, and we are still trying to obtain information and say that that is a ridiculous example of a system that has flaws. A system which, quite frankly, the members of the council and staff now admit should never have been conflicted to private attorneys. And once it was, 4 attorneys were hired, out-of-state attorneys were brought in, millions of dollars were spent. I recognize that the prosecutor probably overtried the case. I know that, and I know that drove the cost up as well. But let's be realistic. The people of Georgia can look at that case and honestly, with common sense, realistically say that is a ridiculous example of a system that has flaws. a system where you have a person, an accused rapist who is now a convicted quadruple murderer who committed his crimes in front of eyewitnesses and videotape with more evidence than you can even imagine, and a case in which millions upon millions of dollars and many years passed before the case could even be brought to trial. And that's the type of thing I'm talking about. I'm not suggesting that Brian Nichols shouldn't get a defense. I'm not suggesting he shouldn't get a constitutionally adequate defense. What I'm suggesting to you is that there is a balance, that it is not an unlimited checkbook, that when we appropriate money out of the state general fund, we have to balance all the state's priorities. So when you spend dollars on one system, whether it's a constitutionally mandated system or not, you are taking scarce resources away from other needs like children's health care, public safety, and homeland security, and many other things. And that has to be a balancing act. So I have tried to work with the council. The House members have tried to work with the council on the Oversight Committee. The Oversight Committee has been derided for looking over the shoulder of the council and asking for information. We have asked for an accounting, and that accounting has been flawed. It has been admittedly flawed by huge numbers, 100% numbers. Last year, for example, we had a request for emergency funding for over 9,000 cases, which we were told were in the pipeline that were conflict cases. And so on that basis, we appropriated $2.5 million to help cover the 9,000 cases that were in the pipeline. And then some months later, after the money had been spent, we were told that that was actually an error in accounting, and that it was inflated by more than 100%, that there were actually less than 4,500 cases in the pipeline. Now they've come back and shifted their response a little bit and said, well, there were still some costs associated with cases that weren't in the pipeline. Keep in mind, these were cases that didn't even exist at the time they asked for the emergency appropriation to fund them. And frankly, and this is another thing I'm talking about, what would really help would be a transparency where they would come back to us and say, we made a mistake. We asked for money on a basis that that it was flawed, and half of that money was appropriated for that purpose should be given back to you. And if there is some other need that we have, make the case for that need. Instead, it's a shell game. If you ask, a request is made for money for one purpose, that purpose may be shown to be false. When you point that out, they say, well, we asked for $400 per conflict case for 9,000 cases, and although we only had 4,400, we've appropriated $800 per case for those, so you still owe us the same amount of money. And that's the trouble we've had in dealing with this. What we're asking for is a predictive model at some level. We know there will be exceptions. We know there will be exigent cases. We know there will be unusual circumstances. We know there will be cases which require the expenditure of money for experts and costs which exceed the average. But we ought to be able, as a legislature, to sit down and say, this is, on a macro level, what we can expect to appropriate, and then we can look at the examples when there are unusual circumstances. But this is what the system should or ought to cost, and it probably ought to have increases over time periodically, as every other expense that we have as a state does as well. But we've had an inability to get a predictive model. We've had consistent criticism of legislators and their motives for trying to work through this. I've spent countless hours trying to get work with House members and trying to get to the bottom of some of these issues, and all we get is derision from the council. A significant amount of time was spent with the council determining the best way for them to budget. And frankly, the council decided that the best way for them to budget was not to be in the judicial branch. And we had these discussions with them. The Supreme Court asked us not to have the council in the judicial branch because of the impact it was having on their budget. And they would ask us for their budgeting purposes if we could appropriately move them to a different branch of government. That was a request and a discussion that was made by the Supreme Court. We discussed that with the council, and they agreed and endorsed that move because they said that they felt like it would give them a better opportunity to budget, starting when the executive branch, where the governor's office could be brought in at the beginning, and then have people that could help them defend that budget throughout the process, rather than having the pass-through judicial budget, where the very first opportunity they had to defend their budget was after the governor's budget was presented and to the House when the House took up their budget. So, on the request of the Supreme Court, in consultation and with the advice and the consent of the council, we made a move a couple of years ago to transfer them into the executive branch. Almost as soon as we did, we were criticized for doing so, and a significant amount of the council's time was spent in meeting after meeting talking about whether and how they could sue us to transfer back into the judicial branch. And they, in fact, asked the Attorney General of Georgia for an opinion about whether or not they could bring a lawsuit against us to force us to transfer back into a branch of government that they had agreed to transfer out of. And the Attorney General in January of this year issued an official opinion which in no uncertain terms said, no, you cannot sue the state. You are an agency of the state. And moreover, it is not on its face inappropriate to be in the executive branch. And the Attorney General did a study of all the state systems and found that there was a mix, that about half the states had them in the executive branch and about half of them had them in the judicial branch. And my point in telling you that is twofold. One, it is another example of how the council's approach to us has been adversarial rather than as a partner to provide this service. And number two, it is that I bring that up because the Attorney General has said, and I argue to you, that there are different ways to structure this system. The argument will be made to you that this is the only or perhaps best way to run this system with a council that sets policy and then has some sort of adversarial relationship with the legislature and its own staff. And in fact, if you look around at other states, and I'll provide you with the research if you'd like that, every state that has a statewide system does it differently. And many states have a system with an appointed chief defender or public defender that is in the executive branch or appointed by the chief executive or governor. So the notion that this is the only way to structure the system, or perhaps the best way, is also not supported either by the Attorney General's opinion or by a study of the other states' process. One of the biggest problems we've had with the council has been that they have gotten completely sideways with their own staff. And they have, for example, issued statements to the Oversight Committee that their own director, Director Crawford, is not authorized to speak on their behalf, and that his statements may not be made to us until they have cleared his statements in advance. They have made the same statement about the director of their conflict program. So we now have a state agency who has a council that can't get along with its own director, who won't allow its own director to come to the Oversight Committee meetings, the Appropriation Committee meetings, and speak on its behalf. So his hands are tied. He is obligated to balance, as a director of an agency, to present a plan for a balanced budget, which he has done and attempted to do, and then the council has directly overruled him and prohibited him from bringing that plan to us. In recent months, they have proposed to hire a new position that will be their liaison, that will duplicate the position that the staff director ought to be carrying out, the functions of which are almost identical in their job description, and would be a duplicative bureaucratic position hired by the council for the same purpose that they already have the director, who they currently can't get along with. I guess I would summarize this by saying to you that we have worked very, very hard and in good faith to try and get this system birthed and to try to get it raised. And we are now sitting 4 or 5 years out from its initiation, and we are having discussions floating around from the State Bar and members of the council that the system may cost $120 million, it may cost $160 or $180 million. And the argument being made to us is there is no way for us to tell you what it should cost. But every time we come to you, it's never going to be enough. And the council itself has placed an adversarial burden on the legislature that need not exist. We don't have to run a system that is adversarial with the agency that carries out the function of the policy the legislature has determined. So I would suggest to you, and I will certainly take questions, I would suggest to you that what we are doing with Senate Bill 42 is an effort to allow this system to survive. And in fact, to set it up for success in the future. There are many people that are beginning to argue that there was better representation under the previous system than under the current one. And there are some arguing that the counties that have fared the best under the new public defender system are the ones that opted out altogether. And I hate to hear that, and I hope that that is not true. But if it is true, then the answer is not for the council to accuse the legislature of being kidnappers, murderers, and thieves. The answer is come to the table and work with us in a way that will structure a system that will succeed. Director Crawford has brought to us plans, both in the conflict area and in the overall structure of the system, that would allow for us to succeed, that would allow for us to move forward, and frankly, in some cases, would allow for us to spend additional monies to provide for the system. The council has not allowed him to do that, and so he has withdrawn those requests. And at the final meeting the council had a few weeks ago, when the state was facing an enormous revenue shortfall, when we were facing tough decisions about cutting money to education, to Medicaid, to children with disabilities, to public safety and law enforcement, the council had a meeting. They decided not to pass along the recommendations of their own director, and instead, in overruling him, voted to submit a 2010 fiscal year budget requesting a 33% increase of $12 million in enhancements, with all sorts of new money, including pay raises for their staff. And I would tell you that, and argue to you that that is an example of a council that is so totally and completely out of touch with where the state is fiscally, and so out of touch with the policymakers' struggles that we're having, that they have thumbed their nose at us, they have taken their ball and gone home, and they have said, we don't care what you do, we're going to spend this money anyway, because we believe, they say, that they're required to do that. They acknowledge in their meeting that they are out of money, and they have directed their own council director to spend the remainder of his money on conflict cases such that he will run completely out before this fiscal year ends. And for the fourth year in a row, we will have a fiscal emergency in an underfunded agency based upon a failure to live within its own budget. That is not the way to handle any agency in the state. Whether you believe that you are charged with providing a constitutional duty or not, there are fiscal responsibilities, there are scarce dollars to allocate. And when you say to us, we know we're going to run out of money, and we don't care, then we need to make a change. Senate Bill 42 will restructure that council to create an advisory body that can assist the director, but it will empower the director to set policy, to make decisions, and then be accountable for the results of those decisions. And I would argue that that structure evidently is what Georgia needs to do, because the one that we tried with the council has failed, and we cannot continue down a road of failure. The provision of this service is just too important. With that, Mr. Chairman, I will stop my prepared remarks, and I will be happy to try to answer any questions you or the committee have.
Thank you, Chairman Smith. You know, I was around for House Bill 1EX and was not intimately involved in it, but was serving as the governor's floor leader at the time. I do remember, and separate apart from the conversations that the former Chief Justice had with the governor at the time, which I realized was an ongoing exercise and an ongoing negotiation, I don't remember anything, and it's been a while since I've taken a look at 1EX. I don't remember anything in the legislation that would have given any sort of direction, understanding, obviously, as the gentleman said, we can't earmark or dedicate in the absence of a constitutional provision saying that it is so. I don't remember anything in the legislation prescribing a particular amount, prescribing a method. Can you speak to, were there any provisions at that time that you can recall, and I just haven't reviewed it thus
Sure.
far, any provisions within that legislation that would have given any reasonable mind, lawyer otherwise, council member otherwise, some sort of underpinning, some sort of foundation for taking a hardline stand about the use of those particular fees and monies that were generated as part of the system to be the funding mechanism, again, understanding, right, not dedicated. Because it seems to me that that's the background of the question, but that's the question. The background of the question is there seems to be a disconnect. The word that I heard you use more than anything just now is balance. And there seems to be a lack of balance, and there seems to be a very, I wouldn't say narrow because I think that's an inappropriately disparaging description. There just seems to be a very determined, a perception of determination on the part of some that balance need not matter. Can you speak to 1EX at the time? Mm-hmm. And I don't expect you to have it right there in your back pocket, but about why it is that people would have that kind of, some people would have that type of very militant view, I think, is not inappropriate. Militant view as to how those funds should be spent. Are there limitations, and perhaps not in the minds of some? Can you speak to that?
I will, Mr. Chairman. Thank you for the question. The House Bill 770 in 2003 actually created the system, and then we created the system and then discovered, as we sometimes do, that this was one of those ads or mandates that there really had to be additional revenue for, because to pull that sizable amount of money out of the general budget at the time was not feasible, wasn't possible. So we came back into a special session. You can imagine the need that would require us to do that for this one purpose, and that was House Bill 1EX, and the purpose of that was to create a revenue stream to help fund this need. And there was no prescription for it. It was set up to provide a fund that would give us some revenue to help fund this system. And the only comment in that spoke to a relationship between the dollar amount raised and the budget of the council or the overall agency was that they were not allowed to request in their appropriation request more money than was raised by that fine and fee collection. Now there's actually a number of streams of revenue that help us fund this. The counties obviously provide even still 60+% of the revenue for this system, and there are 3 other revenue streams. In fact, for some time the Supreme Court had given an order to the Georgia Bar Foundation to use IOLTA funds, and they discontinued that 2 years ago as well. And they were providing more than $1 million to the system through that as well. But there was no direct linkage between that, other than that they could not make a request. And of course that request was subject to what the appropriators and the legislature generally felt like was needed. But the request could not exceed the amount raised. Somehow, in their minds, that transformed into a real sense of entitlement to all of that fund. And contrary to every other agency which understands that the revenue stream still has to be appropriated, and that you often don't get all, sometimes it's not all recognized by the governor, frankly, in the revenue estimate. They argue over and over and over again, although if you ask them directly they say we don't, you will hear it, that they are entitled to and believe they should receive 100% of that fund. Last year in one of the bills that we passed to make adjustments to the system, we actually removed that linkage altogether. So the limitation on the request does not exist at all anymore. And frankly, they can ask for less, they can ask for more, they can ask for the same that's raised, but there is no linkage at all established between that revenue stream and what their budget should be.
I appreciate the gentleman's answer, and it really goes to the issue of, and I certainly only speak for myself. It's not an indictment of the council as a whole. There are great members of the council. It's always a mistake to go ahead and condemn an organization over the unfortunate comments and characterizations of really what end up being just a few, and maybe even fewer than that. But it does go to the issue of balance, and it does go to the issue of if an organization and individuals within an organization are going to take such a strident stand, and these are bright people. I mean, these are bright people. These are people who were chosen for their judgment, for their scope, for their vision, for their perspective on this issue and other issues as well. One can reasonably presume that if some, again, just some, in an organization are taking such a strident position, that surely they must be relying to their detriment on X. And I'm just trying to figure out what X is that has caused what I perceive to be a lack of balance and priorities. And of course, that's why we're here. And I appreciate the answer.
Can I add one thing to that, Mr.
Yeah.
Chairman? And I completely agree with you. And I will tell you that I've been contacted by members of the council who support Senate Bill 42 and who feel like that a minority on that council have essentially taken over the policy and are running over the other members of the council. I've also and when you see public statements against legislators that call us kidnappers and murderers and thieves, that's not a reflection of rational thought or reasonable discourse. And it's not constructive; it's destructive. But I will also add that the public defenders that serve in the circuits are by and large, almost without exception, outstanding people who work in a very tough environment and do a job that is not only thankless, but many people don't understand and often don't agree with. And so they have, so those people that I consider to be sort of in the trenches, not in the ivory tower or the central office somewhere, they work hard, they do a good job, and they need to know and feel our support. And they contacted me in this process, and they said, we have one request, and that is we're a little bit concerned that if in Senate Bill 42, if you consolidate power in a director, we're concerned not with our current director, but with a potential future director, that he would have the ability to fire at will circuit public defenders with whom he disagrees over decisions. And we feel like that's not good security for us, and we would like to have a due process built into any removal provision for a circuit public defender. I took their recommendation almost verbatim and built into Senate Bill 42 a removal provision that is very, very similar, almost identical to what we use with sheriffs and clerks of court, to where if there is a complaint by the director or the council or the governor is allowed to initiate an investigation commissioned by a panel of 3, 2 of which are circuit public defenders. And they can make a recommendation upon the receipt of which the governor can suspend the circuit public defender, and he or she will have an opportunity for a hearing or a trial on his or her removal. I built that into Senate Bill 42, and with that, the circuit public defenders said, we don't take a position on the bill, but we need your support, and we need to be funded appropriately, but we don't like this friction the council has with the legislature or the staff either. It's causing us problems too. And so I appreciate them working with me, and I would be remiss if I allowed my comments to be interpreted to be in any way a reflection of a disappointment on the CPDs, because I have none.
Understood. Ms. Benfield.
Thank you. I have sort of a big picture question, and I have a few specific questions, if that's okay. The big picture question is, how much of this is personalities of the individuals currently in place, and how much of this is truly a structural problem? And I bring that up because in DeKalb County, we've really grappled with changing our government structure, and frankly, a lot of it had to do with personalities of folks who were in office at the time. And so I was really reluctant to make some of the changes based on what I saw as sort of personality disputes. So I'm interested in your assessment. How much of this is personality? How much of this is truly some structural issues that need to be addressed?
I think it's a great question, Representative, and I myself wondered that, but I think the answer has to probably be that it's a combination, but clearly a structural role plays a part in this, because we have had a change in personnel at the council and the staff level, and we continue to have similar problems. Emmett Bondurant is no longer the head of the council. Mike Mears is no longer the director. We have had a number of new council members added in the last 2 years, and they have taken up and made similar comments and taken up similar policy positions and failed to understand the need to reach a balance and a partnership with us. So I think ultimately, for whatever reason, there is a view of the council that providing indigent defense means one thing, and all the rest of the state budget can be subordinated to that need based upon their subjective view of what it means, even if it's inconsistent with our court's appellate decisions and the Constitution. And that view seems to permeate the council regardless of who sits on the council. It does not permeate the staff. The staff has come to us with reasonable accommodations. They have worked hard to provide us with numbers and with policy recommendations. They have made mistakes, and they have acknowledged some of those mistakes, and that's a sign of a real mature leadership style. And we appreciate, while we haven't always agreed with them, we've appreciated their willingness to work with us and try to get us information that we've asked for and help us partner with them. Not true with the council. When the council tells the director he can't speak for them and then they don't attend a meeting, we have an appropriations meeting, we have an oversight committee meeting for the purported reason of looking into the activities of the council without anyone there to speak to us. And so that's just clearly there is a structural problem that we need to address. I wish it wasn't. Ideally, I would like to see a structure like we have work, but it clearly has become dysfunctional.
Let me ask members for a question and then a follow-up that'll allow us to get around the horn once, and then we'll see where we are in about half an hour.
Okay.
Please.
I'll follow up with my questions.
Thank you.
Other questions later. Thank you.
Very well. Thank you. Ms. Abrams.
Thank you, Mr. Chairman. Senator Smith, can you give examples of states with similar structures that are currently in place?
I can. Now, similar to the proposal that we've
Yes.
made, there are 14 states that have a structure with a chief defender or officer appointed by the governor that is a director. And those 14 states include Alaska, California, Delaware, Idaho, Iowa, Kentucky, Mississippi, Nevada, New Jersey, New Mexico, Rhode Island, Vermont, West Virginia, and Wyoming.
Thank you.
In alphabetical order. But now I will say as a caveat to that each one of those states is structured differently. That's what's interesting about the argument that we're dismantling the system or destroying the public defender system. Each one of those, even those that have an executive appointed by the governor, has a different arrangement. And so there's not a cookie-cutter approach, but it is clear that there are different styles to structuring the system.
And as my follow-up, which of these states would you say has a system most akin to the one that you're proposing currently?
I don't know how to answer that other than I can provide you with some research on what the breakdown is of how they're structured, because we didn't try to model this. We tried to use Georgia's existing structure and fix the places where there was a problem rather than redesigning a system based upon another state's model.
Thank you. I would appreciate that research. Thank you.
Mr. Knox.
Mr. Chairman, thank you for your remarks. And let me ask you if some of the problems that we've seen, from funding to operations, don't go back to a basic misunderstanding, I think, about what the mission is or ought to be of the state program as we have established it. And that is that I think the mission is supposed to be not to have a particular system necessarily, but that we have decided that some system needs to be in place, because the real goal is to provide an attorney for every accused who can't afford one. I think that's basically, essentially, the whole 9 yards right there. And there probably are more than one way to do that. We've seen that across the country. There are different systems for delivering that. We've seen in our own state that there are different systems for doing that. Prior to the enactment of this legislation, we had some excellent systems in operation that did an excellent job, never had any problems about providing representation for persons accused, and we had some systems that weren't so good. So it seems to me that makes an absolutely good argument for saying that we ought not to be focusing, as we have so far, on establishing and enshrining in law this construct that we have developed that we call the council or the state program or the other terms that we've used for it. And I think this goes to budgeting and everything else. Would you agree with that?
I do, and you know, I will say that this system is the product of a lot of work and many years of discussion. A Blue Ribbon Commission by the Supreme Court and the State Bar participated heavily in designing this system, and I know that there are people that have a great pride of authorship in the way this system was designed and structured, and they honestly feel this is the best, and perhaps they feel it's the only way to run the system. And I have a great deal of respect for them and their minds, and I think that they designed a system that was intended to do a good job. But clearly, as we go forward, we have to have a system that actually works, not just one that works academically, but works in practice. And I guess the clearest way to give you the example of that disconnect is we had a meeting about a year ago, and we were discussing what it meant to provide an adequate defense. And one of the people testifying asked me, he said, if you were going to get a neurosurgeon, wouldn't you want the best neurosurgeon money could buy? And while I understand that those who practice in this area and are advocates for strong criminal defense feel that every indigent and any other person accused of a crime should have the best that money could buy, the best neurosurgeon you can get, that is not what the Constitution says. And that is really at the heart of what this disconnect is. You have a group of people who run the system who really believe you need the best neurosurgeon money can buy, and you have us as policymakers looking at the Constitution and the appellate court decisions and saying that is not our obligation as the guardians of taxpayer dollars and money in the state general fund that we appropriate to provide the best neurosurgeon money can buy. Our obligation is to provide a constitutionally adequate defense for the indigent, and that's the discussion we ought to be having, not how much can we spend on the defense of an accused person. Clearly, if you have the kind of money O.J. Simpson has, you're going to be able to afford that kind of defense. Clearly, not everyone can pay 4 lawyers, spend millions of dollars, and have a trial that lasts that long or in which that much resource is placed. But that is not, like it or not, what the Constitution requires.
Mr. Chairman, did you say no follow-up or one follow-up?
Please follow up.
Okay.
Just limit to one follow-up for now. Thank you.
Just as a practical matter, and this is what I see as part of the problem with the at least with the budget crisis part of this, and that is that we can't really afford to reserve or to fund for a situation that would allow us to provide what you just talked about, the absolute best neurosurgeon in the world to perform neurosurgery for everyone who may need it. Can't do it. Number one, even if we had the money, we probably can't get him to do it because he may be doing surgery on somebody else when we need him. So it would be silly to have that kind of money set aside for every case. And I think that's what the mindset is about this whole funding issue, is that that's how we need to fund things. And for every case that comes down the pike, we have to have money set aside to be able to do just that. Would you agree with that?
I do, and Representative, I have been appointed by judges to represent indigent defendants, and I have then taken my bills to them, and they have reviewed my bills, and they have made adjustments to those bills, and no one more so than federal judges. When appointed to represent someone accused of a federal crime, a federal judge will not hesitate to strike your fee, to cap the amount that you spend on experts, to reduce, and the remainder of which you either pay for out of pocket or you don't spend. But there's an attitude now that we cannot suddenly do that. Even though the federal court system does it, somehow the state court system has to have an unlimited funding of this without any restraints, and that's just not practical, reasonable, or even ethical. And frankly, to the extent that you spend $2 or $3 million on a Brian Nichols, you're keeping us from actually fulfilling our mission, which is providing counsel to all the rest of the indigents in the state. And that's why balance is needed.
Mr. Levitas.
Thank you, Mr. Chairman, and thank you for bringing this bill. And I had the pleasure of serving with you on a committee that studied this, and I experienced some of the things that you remarked on. I did have a question. Why did you choose in the bill to remove the judicial appointments?
That's a good question. The answer is I did not, and it's misleading because there's a strike there. But the only reason there's a strike there is because it was removed in the previous bill that passed a year ago, when the agency was transferred out of the judicial branch, again at the instance of the Supreme Court and with the cooperation of the agency, the judicial branch no longer funded it with any IELTA money. They no longer had any oversight. They no longer had them placed under their budget. And so we made a decision, and we all passed, House and Senate passed a bill to eliminate the judicial appointments from the council a year ago. It did it at the time it passed. It was a prospective ending of that appointment power on July 1st of 2008, I believe. Now that we are dealing with that code section and that date is behind us, Legislative Council struck that as a matter of cleanup, because anytime we come across a formerly prospective code section that's now in the past, it's irrelevant, and so they struck it. So while it appears at first glance that we're removing those appointments, we in fact are not doing that. There is no change whatsoever to the appointment structure.
This is something I know that we've wrestled with, and I don't know that there is an answer to this, but I guess what troubles me in converse is either a council or a mindset among some, and I I've been a defense attorney, and I think public defenders serve one of the, if not the most important role in our judicial system. But there seems to be a mindset that we're going to blackmail you into providing what we think is an adequate defense. And by that I mean that we're going to spend, and we know that if we bankrupt the system, that you still have an obligation to provide a minimally adequate, constitutionally adequate defense for all defendants. So we don't care what you say, we don't care what the legislative intent is, and we, right, frankly, don't care what the impact is on the system overall. How will either this bill or some other bill provide us, and by us I mean those in charge of safeguarding taxpayer money, with the tools to prevent or limit instances of this? Is there a way, either in this bill or through subsequent legislation, to have some kind of fiscal responsibility imposed upon those who don't impose it upon themselves?
Well, it's a good question, and I agree with the presupposition of your question, which is that for 4 years running now, each year the council has lived outside of its budget and then come to us and said we're in a crisis. And this year there was a meeting on August the 9th of this year, I believe, September 26th of 2008, of last year. And Wycor made this comment. It very perfectly summarizes the process they've been engaged in before. He says, I think this was in response to a request by the governor that the council participate in every agency's reduction at a marginal level so that we could balance the budget. And Mr. Orr says, and I'm quoting him, I think we need to engage in no cuts, no furloughs. We go as far as the money let us go, and then when we cannot go any further, then it means that criminal prosecution in the state gets shut down, then that is a crisis the state will have to deal with then. Moments later he said, I urge the county not to even be a party of this, not to cut its budget, not to submit a budget reduction scenario, to say that we won't be a part of this. We'll take this system as far as we can with the money we got, and when it runs out, and it won't be our fault, it'll be theirs. That is, in fact, the method that's been used. It's creating what we call a coercive deficiency, which is, as you put it, blackmailing us, intentionally running out of money by delivering a service beyond that which the code and Constitution calls for, and then coming to us and saying, we have a crisis, and we're going to shut down the judicial system because we haven't lived within our budget, alleging that we haven't properly funded them, which evidently can never be done. So I think the first part of your question is valid, and that is that there is this coercive deficiency mindset that they're going to threaten to sue us or threaten to shut down our system if we don't give them the money that they say that they have to run the system. And secondly, I don't know that all of these problems will be solved by changing the structure. I do know that the director is required by code to submit a balanced budget scenario and to live within his budget. And so the council views themselves as not having the same obligations as their staff director, so they overturn him and don't allow him to produce that, putting him in a very odd position with respect to the rest of the agencies, because the council is telling him he can't submit a balanced budget scenario. The code calls for every director to submit a balanced budget scenario and live within your budget. And so it's a horrible structural conflict that we have right now. I think there's going to be a continuing process to work through, and we will have to trust that they're going to work with us and partner with us. They have shown the staff has shown a demonstrated willingness to do that, but have been unable to do it due to the restraints of the council. And I don't know that we solve all of that with this, but we do remove this coercive deficiency mindset of the governing council.
Mr. Ramsey.
Thank you, Mr. Chairman, for your comments. And this is very much related to the discussion you and Representative Levitas were just having. And just for my own education, you spoke a little bit about an emergency appropriation last year based on X number of cases that were in the pipeline. That turned out not to be true. Can you speak to the process they engage in every year in terms of setting their budget? Is there a formula? They have X number of cases that each case takes on average this amount of dollars. Is there a formula in place that they come to us and making the request on an annual basis?
The answer is no, I can't, because we've been asking that question from them and have not gotten a response. Now, I think Director Crawford has in good faith attempted to share with us what the various sub-programs need in terms of funding, but other states have actually placed into their code the amount that they will pay for a conflict case, and they stratify those based upon the class of case. A non-capital felony that carries a sentence of X years. Create levels of cases based upon their penalty or category of case, and then say this is the amount we're going to pay. And what you do then is you can actually go to a conflict attorney and you can contract with him or her, and you can say, we'll send you 10 or 20 or 30 cases, and the cases will pay this much per case. So while one case may run slightly under, another case may plead out, and you may end up with a surplus. And on balance, they can say, well, if I take 10 cases at $1,000 apiece, I know that's $10,000, and I know that those 10 cases, one may cost more, one may cost less, but I can certainly budget for that. And several states have done that and placed that in their code. We have refrained from doing that, but we have asked them to produce to us a system average of what different categories of case cost so that we will know. And they are working on that right now. Although they're restricted from talking to us, the director over the conflict system has said, I've got a pretty good model, a pretty good idea now, because we've had several years of what these cases should cost and what they are costing, and I can pretty much tell you. And that's the kind of thing we need. We may end up putting it in code. I would prefer not to. I'd prefer for there to be flexibility. But in fact, that would be the ultimate predictability, is to do what New York and some other states have done and say, for this case, this much the state will pay. Some of those states do have judicial escape valves built in, so that if in a given case there are extraordinary circumstances or costs, that can be accounted for. But on the whole, it does create predictability, and that may be the direction we should go. I would like for us first to take the intermediate and incremental step of them saying, we can show you how many cases we have and how much it should cost, and you can budget on that basis, rather than us saying, we're going to impose that by statute.
I'm not suggesting that. I mean, it just seems to me that's kind of at the heart of this whole thing is what is an adequate defense, and it comes down to money at the end of the day. And if we need to know what process they're engaging in to determine how much money they're going to ask for these cases on a case-by-case basis.
And I'll add to that, Representative, that Illinois has a unique model, somewhat like Georgia. I don't want to take that analogy too far. They have a major municipal city in Cook County, and they actually cap the amount that they pay on these conflict cases and create a different tier for Cook County cases because the cost is presumed to be higher for the whole process, the time it takes, and the experts involved than it would be outside Cook County, which probably is not unlike Metro Atlanta and the rest of Georgia. Again, that may be something that we look at. It's not proposed right now.
We've got about 5 minutes left until members have to be excused to get up to the floor. Let me just touch on one point. We've talked about dysfunctionality, balance, lack thereof. Let me talk to you about management just for a minute. In any organization, you have a staff person. In this case, it's the executive director, who happens to be Matt Crawford at this point. But as he touched on at a point earlier, it's not about right now. It's about a generation from now. So much of what we do is not about the here and now. It's about when our kids are our age and what's the system going to look like then. We've seen other examples in other branches of government, some notable, some not so notable, about staff folks serving two masters, being pulled in different directions. And I think where we are as a General Assembly, I think from a bipartisan standpoint, frankly, are going in general in terms of management, operational management, is look, if we have a priority, if we have an imperative, and indigent defense is an imperative. It is a constitutional imperative. It is a moral imperative, in my opinion. That being said, we have to have someone in a position who has the responsibility and the tools and the accountability to get the job done without being pulled in different directions. It's not special to indigent defense. It's government in general. I see that as being a very important part of this bill we haven't touched on yet. We're going to. Could you speak to that for just a few minutes? And I'm sorry we're a little bit limited this morning, but I wanted to make sure that we touched on that because it's very important to keeping the wheels on the track in this discussion and in other discussions in terms of pure governance.
Yeah, I agree with you, Chairman, and that's the reason why we went and studied the other systems in other states, not because we wanted to model after them, but because I wanted to make sure that there are systems that exist where there are independent chief prosecutors or directors of an agency which are perhaps appointed by the governor, but who still exercise that independence, whose systems have been upheld, who have functioning systems in place. Because I think that's a fair concern, is whether or not you have someone pulled in different directions depending on who they view as their boss, so to speak. But the bottom line is, the other systems do work. And so we know that there is not just one way to do this. And while I think it's a fair concern, we know that this structure has failed, and we're looking for ways to make it succeed for that future generation, and even now in this case. And so, given that there are examples, empirical examples of where it has worked, I think it's fair to make the attempt to see if this can help us solve some of these problems. And I realize that we may have a different governor, and we will have a different governor. We will have different directors of this program and different stakeholders involved. But I think the people that are engaged in this debate, while they sometimes say irrational and unreasonable things, have a genuine concern and want to make this work on all sides. And I don't see, and I don't think it would even be possible for a governor to intervene into a system and affect the direction or the type of defense in a case, for example, or anything like that, simply because he appointed that person to run the agency. That hasn't happened in the other states, and I think there's a seriousness of purpose with this issue, and also, quite frankly, if that had happened, it would go to the courts and be overturned, that intervention. So I think people understand that this has to be an independent system, and I think there are just more than one way to create that independent system.
Thank you. Good conversation this morning. We'll continue this tomorrow morning at 8:45 a.m. We'll meet from that time until 10. Then we'll pick it up again tomorrow afternoon at 1 p.m. Original notice at 1:30. It's going to be 1 p.m. back here tomorrow afternoon, and we'll see how far we get. The first up tomorrow, of course, will be response from the council, and we'll take it from there. Thank you very much. We're adjourned.
Thank you, Mr. Chairman. Members of the committee.